Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Limitations of Liability for Maritime Claims, an Unbreakable Limit. On the 26th May 2021, the Court of Appeal delivered a judgment in the names Maroc Blue Tuna Farm Limited v. Daughter and Vintage as special mandatory for the vessel MV Coral Waters. By way of factual background, back in 2006, the vessel MV Coral Water has departed from Porto Torres in Sardinia for Tuzla in Turkey and stopped off Malta to take bunker. Shortly after taking bunkers and setting sail at night and it forced 5 until 6 weather, the vessel propeller got caught in the mooring ropes of an aquaculture. The owner of the fish farm alleged that as a direct consequence of this collision, the vessel had torn the netting around one of its tuna cages, causing approximately 207 gross tons of blue fin tuna to escape. The claimant alleged that this amounted for a catastrophic loss of nearly 2 billion euro over and above the claim for physical damage suffered to the cage, which owner quantified at approximately 70,000 euro. The owners recommended an actions for damages and requested the court to declare that the alleged loss occurred as a result of gross recklessness and with knowledge that the incident was likely to occur. The first court dismissed the claim on the ground that the claimant had failed to prove that the MV Coral Waters was solely responsible for the incidents due to gross negligence and at the same time acted with the knowledge that an accident of this sort was likely to occur. The plaintiff company appealed in May 2021. The Court of Appeal determined that the master failure to use the appropriate chart amounted to gross negligence on this part. The court thus went on to partially overturn the findings on the first court, determining that the claimant's first request was merited. However, and most importantly, in delivering its decision, the Court of Appeal found that this was largely a fictitious claim, dismissing the 2 billion euro claim for the alleged loss of tuna. The court has relied upon the extensive evidence produced by the defendant vessel that proved that at the time of the incident, the relevant tuna cage was in fact empty and therefore no tuna could have been lost. Nonetheless, the court ordered the defendant vessel to pay the sum of 15,000 euro in damages caused to replace damaged equipment and cover the cost of labor, finding that the incident was caused due to negligent passage planning by the captain of the MV Coral Water. In this instance, the amount of damages awarded was minimal. It did not trigger the vessel need to limit its liability. Accordingly, the court was to find on the issue of limitation of liability. However, by accepting the claimant's first request, the court appears to have, perhaps inadvertently equates gross negligence with the requirement to break limitation found under Article 4 on the LLMC. This begs the questions: had the damages award been greater, could the court finding of gross negligence have led to inability of the ship owners to limit its liability? As stated by law denying in the Bremler Moore, limitation of liability is not the master of justice. It is a rule of public policy which has the origin of the story and its jurisdiction in convenience. It has also been described as a concept whereby the principle of limited liability is that the full indemnity, the natural right of justice, shall be abridged for political reasons. Indeed, limitation of liability provision in a sense are expressly designed for the purpose of encouraging shipping and affording protection to ship owners against bearing the full impact of heavy and perhaps crippling pecuniary damage sustained by reason of the negligent navigation of their ship on the part of their servant or agents. Malta is a party to the convention incorporated by means of Schedule 4 into subsidiary legislation. 234.16 entitled Limitation of Liability for Maritime Claim Regulation. Article 1 of this convention defines which person may be entitled to limit liability. It refers to ship owner defined as the owner, charterer, manager, and operator as a seagoing ship. Sailors and persons for whose act, neglect, or default the ship owner or sailor are responsible. They shall be referred as the relevant person. Article 2 of this convention states that a person entitled to limit liability may do so in respect of loss of life or personal injury, or in respect of loss resulting in damage to property occurring on board, or in direct connection with the operation of the ship and consequential loss resulting therefrom. The convention specifies that the limit of liability for a claim arising of any distinct occasion shall be calculated according to a sliding scale based on the vessel's tonnage measures in units of account, which is then converted into a monetary feature by reference to special drawing right, as established by the International Monetary Fund. However, the right to limit liability is not absolute. Under Article 4 or SL 234.16, which replicate and verbatim the provision of Article 4 of the LLMC, a person liable shall not be entitled to limit his liability if it is provided that the loss resulted from his personal act or omission committed with the intent to cause such loss, or recklessly and with knowledge that such loss would probably result. The threshold to break limitation is necessarily a high one, as it would otherwise defeat the purpose of such limitation. The following element must exist: A person liable by the person act or omission caused loss with intent recklessly with knowledge to cause such loss. A person liable under Article 4 refers to the person who are entitled to limit liability. In example, the relevant person mentions under Article 1 of the Convention. This would include person whose act, neglect, or default the ship owner is liable. Under Article 347 of the Merchant Shipping Act, Chapter 234 of the Laws of Malta, the ship owner is responsible for any damages caused by act or omissions in the navigation or management of the ship. Thus, the act or omissions by the captain of a vessel to conduct an adequate appraisal of a passage plane could satisfy the first two criteria. With respect to the third requirement, the court dismissed the claimant allegations that he suffered a loss of €2 million as false. They say, technically speaking, the court did conclude that a loss was caused by the incident, albeit the minimal one of circa euros 15,000, thus whilst the damage sustained fell way short of any sum that would trigger the limitation of liability. It could be argued that the third element of loss existed. Nevertheless, gross negligence should not in itself mean that there was specific knowledge, nor cause a particular loss as is required to break the right of limitations of liability. So that's all the article. Bye bye and see you on my other video. Bye.